Thanks for being here, everyone. Today, Tamara, Allyson, Patrick, and myself will take you through some practical tips and considerations when looking to make changes to terms and conditions of employment. Without insulting your intelligence too much, we're going to take you through a quick overview of what constitutes constructive dismissal as drawn from the case law. We'll give you some advice on how to go about making certain changes, and we'll walk through some typical scenarios involving changes to terms and conditions and some risk mitigation strategies. So as you can see from the slide, without using too much legal mumbo jumbo, constructive dismissal occurs when there is a material change to an individual's terms and conditions of employment without consent. The other way that it can occur is through a series of acts taken together that show the employer no longer intends to be bound by the terms and conditions of employment. And Tamara will actually take you through a scenario in which only one act might be enough to demonstrate that the employer no longer intends to be bound by the terms and conditions of employment. The courts are, however, clear to say that not all changes, including minor changes, will amount to constructive dismissal. So maybe getting rid of casual Fridays, that's not going to get you to constructive dismissal. It might make my life easier. One less decision to make on Friday. Okay, bad joke. All of this, of course, is a fact-driven analysis, but the legal test involves an assessment of whether a reasonable person in the shoes of the employee would have felt that the essential terms and conditions of employment are being unilaterally changed in a substantial or fundamental way. And if an employee is found to be constructively dismissed, they'll be entitled to wrongful dismissal damages. So as you can see from the slide, constructive dismissal comes in many shapes and sizes, but typically the change at issue imposes some type of adverse change in the employee's status, so i.e. a demotion or a change in reporting functions. And the change in reporting functions can be a positive change for the employee, but they might perceive it as an adverse change. It doesn't necessarily have to be downward. Reducing an employee's compensation, relocating the employee's place of work, and sometimes, which is a bit more nuanced of an assessment, it involves a poison work environment. So with that backdrop, I'll hand it over to Tamara.
Thank you, Khalfan. So the first question that employers usually have when they come to us and an employee's claim constructive dismissal is, well, what can we do about it? Do we have any defense? So the first line of defense really is to go back to the basic principles. Can you show that the change was not a fundamental breach of the employment contract? And when you're looking at this question, you can consider first the nature and the degree of the change, and second, the terms and conditions of the employment contract. When you're thinking about the employment contract, look for a few things. Helpfully, you'll have terms and conditions that allow for some flex. And unhelpfully, you might have language in your contract that's jamming you up because it's too restrictive. Another thing that you might face is if you have long-standing practices that you're seeking to change, those long-standing practices can become a part of your terms and conditions of employment, so you may lose a bit of flexibility in terms of your ability to change those. The second line of defense that you might have, and this one would be the most effective, is if the employee has condoned the change. And condonation basically is a fancy way of saying that the employee has agreed to the change. And this can take two forms. First, it could be express, meaning that the employee has actually signed off on it. And second, it can be implicit, meaning that the employee has basically lived under the change terms, only disputed them later, and in that sense has acquiesced to those changes. The last topic that we wanted to discuss before we really get into the weeds of this presentation is the duty to mitigate. So the duty to mitigate refers to an employee's obligation to look for alternate work when they've been terminated. This can reduce wrongful dismissal damages that may be owing, but it doesn't apply to any ESA entitlements or ESA required payments. In the constructive dismissal context more specifically, there's case law that refers to an employee's obligation to continue to work for their current employer, i.e. the one that they're alleging constructive dismissal against. For that duty to kick in, however, there's two very specific requirements, and these come from the case law. So first, there has to be an absence of a humiliating, abusive, or demoralizing work environment. And second, the employer has to make an offer to the employee to continue to work during whatever the applicable notice period is. Okay, so with that sort of general backdrop that's going to inform the rest of our discussion, I wanted to jump in and get into the thick of the presentation. So now we're going to start talking about actually making unilateral changes to your terms and conditions of employment and how to go about doing that. So on this first slide, I've set out a case which is called Lancia and Park Dentistry, and it provides a great classic how-to example as to how an employer was able to successfully change their employment contracts. So this case involved an employer who wanted to provide new employment agreements, and they did so by circulating these agreements and giving the employees 18 months notice of the changes. The changes included changes to the vacation provisions, and they also added in a new employment standards only termination clause. So the employees had 18 months to accept these changes, and they were told in writing that they would be terminated from employment if they did not accept. The new employment agreements that were circulated were only going to apply once they were accepted, and the employees were offered a $2,000 signing bonus upon signature. So this particular employee, Ms. Lancia, signed the letter almost right away, accepted the signing bonus, and continued employment under the new terms. Everything seemed to be going fine until 18 months later, when she resigned and claimed that she'd been constructively dismissed. So she was not successful in this, and in our opinion, probably had some questionable legal advice. So what did the court say? So they had two key findings, which are helpful in terms of how we'll strategize these issues going forward. So the first was that the employee clearly consented to the change. She could have rejected the new agreement, but she didn't. And the second finding was that it was well within the employer's rights to make fundamental changes to the employment contract, as long as they did so with reasonable notice, which they did. They gave 18 months. And in that circumstance, it wasn't even necessary for them to have provided consideration. So in terms of takeaways from this decision, you might be thinking, okay, these are very, practical steps that they were obviously successful with, but are they practical in all circumstances where we want to make changes? And they may not be, which is why we're going to take you through other potential strategies that you may have as we walk through 4 scenarios on the next 4 slides. And then just as a backdrop to those scenarios, at the end of the day, we think that the strategy that you take really depends on how significant the changes are, the risks of constructive dismissal, which is why we provided that overarching primer, and also the practicalities of each situation, including how the employee is going to react to the change and what makes sense for the employer and for you as a business. So the first scenario that we'd like to cover is a change in location. So this scenario involves a full-time employee who has been working from home 3 days a week. This allows her to avoid a 50-kilometer commute, and it's an arrangement that's been in place since she requested it when she was hired 5 years ago, but there's no written agreement. It hasn't been documented anywhere. And now the employer wants to discontinue the work from home arrangement. So we've listed a few considerations. The first one is, does the employer have a duty to communicate this change? And in this situation, my view is that yes, they do have a duty to communicate it. Even though the arrangement hasn't been documented, it's been in place since she was hired. It allows her to avoid a significant commute, and this is going to be a significant loss to her. As a second consideration, we've asked, well, what if this arrangement was provided to facilitate childcare? So if the arrangement was provided for this reason, it adds more complexity to the situation. The facilitation of childcare triggers the Human Rights Code family status protection. So not only is your risk of constructive dismissal going to be heightened, discontinuing the arrangement will also create exposure to human rights damages for failure to accommodate and or discrimination. So I would suggest that the employer in this situation act with even more caution in either discontinuing the arrangement if they're going to discontinue it at all, and they should certainly consult with us before implementing this type of change. In terms of how to actually formalize the change, so my suggestion would be to provide as much notice as possible. Typically, I would say that when you're making changes to terms and conditions of employment, the amount of notice that you provide should be proportionate to the employee's length of service. So in this case, I would typically say around 5 months, probably a little bit more than that. In this particular situation, there's also a bit of a gray area. 50 kilometers is a long commute. It's about the distance from Toronto to Burlington. So it's not the longest commute, but it is long, and it's one that the employee relies on. So as I said, I would consider a longer notice period in this case. If the arrangement had been in place for a shorter period of time, or perhaps was something that it was allowed more on an ad hoc basis, I would say that you might have more flexibility in terms of how you make the change. The last consideration that I added is, does the employer have any other options? So what the employer can do here to mitigate its risks is to look for ways to offset the impact of the change on the employee. So for example, it could consider something like offering a gas reimbursement. If there's a willingness on the employee's part to move, it could consider a relocation allowance, or it could even make arrangements for transportation. So there are a few things that you can play around with. So the second scenario that we wanted to walk through relates to changing duties and responsibilities, which is a very common question. Khalfan will jump in to help me out with this one. So this scenario involves an employer who is about to undergo a major restructure following a merger. So in keeping or as part of the restructure, certain employees will have changed roles. This will involve reduced responsibilities and decreased workloads for some, modified reporting structures. However, there won't be any changes to compensation. So our first question was, must the employer formalize the change? And if so, how? So my view is that in most, if not all situations where an employer is changing duties and responsibilities, this should at a minimum be communicated verbally, and in most cases formalized in writing. In this particular scenario, I do see an elevated risk of constructive dismissal because the changes are quite significant, there's a reduction in responsibility, and the modified reporting structure raises some red flags. If the employee is now reporting to somebody who was previously lateral to them or lower on the organizational hierarchy, this can create a perception of a demotion, which can be problematic from a constructive dismissal perspective. In terms of how to formalize the change, if the changes were more minor, you could probably communicate this with a simple written notice, but I would suggest making very clear that essential duties will not change. In a situation like this one, where your changes are more complex, my suggestion would be to provide as much notice as possible, knowing that that's not always practical where you're looking to make these types of changes. So I would suggest giving as much notice as you can, formalizing the change in writing, and ensuring that you're asking for sign-off. I think it's really important to get consent in these scenarios because you might not have the luxury of being able to provide these long notice periods as you may in other cases. And I do find that where there's no change in compensation and communication with the employees is strong, getting that sign-off is going to be more likely, especially if your compensation isn't changes, because at that point, it's not really practical for the employee to reject the change. They want to keep their job. And the last tip I have on this is that it's really helpful to provide a detailed and revised job description so that when the employee signs off, they're specifically acknowledging the changes to their duties, and that will help you defend against a constructive dismissal if the employee later says that the changes weren't as they expected. And the last point I just wanted to hit on before I cede the mic to Khalfan is that this may be a scenario where your duty to mitigate can come into play if the work relationship isn't too acrimonious. That said, if the modified reporting structure has created a demotion, that could trip you up because the employee will have an ability or may have an ability to say that they're returning to a demoralizing or humiliating work environment. But in the absence of that, triggering your duty to mitigate by asking the employer to continue to work in the revised role may be something you could be successful in. So I'll cede to Khalfan, who's going to talk about considerations in the context of a transaction.
Yeah, I mean, kind of stole my thunder by giving that long explanation, but that's okay. So I'm just going to double up on what Tamara said. I mean, it is a question. I'm just joking, by the way. Okay, it is a question that we do get from our clients all the time. In the context of a transaction, certain executives no longer going to be president of the company, but they'll be president of a division. Will this raise the risk of constructive dismissal? The lessons drawn from case law are similar to what Tamara said. And our advice would be the same. Obviously, there's some flexibility afforded to employers in the context of a transaction because they know that there's going to be some uncertainty post-close. But similar to what Tamara said, we suggest engaging early and often with the managers, get as much buy-in as you can as possible, provide as much notice of the change as possible. To the extent you do formalize it, make sure, or try and make sure that you have some language in there where they acknowledge that based on the revised job description, it will not constitute constructive dismissal. And obviously, we're here to help draft that language, and the language will be much more articulate than I'm being right now. So with that, I will hand it over to, there was a lot of build-up for not a lot of talk, but I'll hand it over to Allyson, who will take you through making changes to benefit plans.
So in this, microphone is not my friend. In this third scenario, the employer currently offers continuation of health and dental during leaves covered by LTD benefits. And they would like to make a change to the plan so that health and dental benefits are cut off after 2 years of leave. So what are the considerations? Well, with respect to contractual provisions, documentation such as insurance contracts, employee booklets, handbooks, employment policies, and then other employment communications, and in the union context, collective agreements will all be relevant. Not all of these are contracts per se, but nevertheless can create rights and obligations. With respect to regulatory considerations, human rights legislation protects against discrimination on certain grounds, including disability. So with that in mind, we suggest treating all leaves the same with respect to continuation of benefits. Also, if you're considering other plan designs for restricting benefits continuation, avoid cutoffs determined on other protected grounds, such as age, and consider that some jurisdictions prohibit distinguishing in benefit plans based on date of hire, Quebec, and based on part-time or full-time status. In terms of other legal considerations, we suggest applying the change to future leaves only, as individuals already on LTD are subject to special considerations as a result of being more vulnerable, less able to mitigate the loss, and possibly vested in the entitlement. These factors make it difficult to make changes to their benefits. With respect to communication and administration, changes should be communicated to and coordinated with benefits providers. All employees should be notified of the change, although it would only apply to future leaves. And for leaves to which the change applies, the benefits continuation, the duration of the continuation should be communicated at the beginning of the leave and as the end of the coverage is terminating during the leave. You should enforce the end of the coverage consistently by ensuring employee premiums are not accepted after the cutoff. So to tie all of this together, the key takeaway in making changes to the benefit plan is to ensure that plan terms, communications, and administration are consistent so that the employee has clear expectations regarding coverage, and the employer can mitigate the risk of a claim of discrimination or misrepresentation. So Tamara will now discuss the fourth scenario.
So the fourth scenario that we're going to review involves a poison work environment. So this is a different scenario than the others because the change isn't an express change to a contractual term. The issue here really is whether the employer, by tolerating the type of work environment that we're going to describe, has shown an intention not to be bound by the employment contract, which is the second form of constructive dismissal that Khalfan discussed when he was walking us through his primer. So this scenario involves a company called ABC Co. And ABC Co. is under new management, and the new management wants to rehire a former executive named Sam, who was previously terminated after an investigation found that he had sexually harassed a coworker named Sheila. Now, Sheila informs new management of Sam's past misconduct, but they don't really make any further inquiries, and they just go ahead with the rehire. What ABC Co. does do is they offer to relocate Sheila to another building, but they can't make any guarantees that she won't have contact with Sam. So after this happens, Sheila doesn't return to work. She tells the company that she has PTSD, and she later files a claim for constructive dismissal. So what are our relevant considerations? The first is there a risk of constructive dismissal? And in this scenario, yes, I do see a significant level of risk. The main issue that a court will look at here is whether the employee's continued employment would be intolerable. And from this perspective, I do see a number of risks. First, and significantly, the company doesn't appear to have taken Sheila's information seriously at all. They didn't look into it, and it seems like they've been quite dismissive of her concerns. Second, Sheila's still gonna come into contact with Sam. Nothing's really been done to protect her from this other than moving her. So definitely some risk here. A second question, and this as a variable, is what if the prior misconduct hadn't been investigated in the past? So again, this adds a complicating factor to our scenario because it raises the question of whether ABC Co. now has a duty to investigate, even though the investigation didn't happen before. And in my view, it very well may trigger that duty, and I think it would be very prudent of this company to revisit the past events to determine if there's any merit to Sheila's allegations. This will, at a minimum, show that ABC Co. has responded appropriately and adequately to Sheila's concerns or to what Sheila has raised. And it can also form part of a defense to any claim that Sheila may make that it didn't intend to be bound by the employment contract. So in terms of risk mitigation in these scenarios more generally, what I think the courts will be looking for is really a bona fide effort on the part of the employer to listen to and address the employee's needs and to take appropriate and proactive actions to both avoid the creation of poison work environments, but also to respond to complaints of harassment or complaints of poison work environment when they're made. So with all of that in mind, I'm going to pass this along to Khalfan, who's going to speak about what happens and how to respond when an employee rejects a change that's been made to their employment contract.
Thanks, Tamara. Okay, so we're all experts on how to change terms and conditions of employment now, but not everything's going to go as planned. So if not everything goes as planned and the employee rejects, what do we do now? So the Ontario Court of Appeal decision in Ronco, referred to as the Ronco decision, is relevant to the extent that an employee rejects an offer of employment on new terms and conditions. In Ronco, the employer unilaterally reduced Mr. Ronco's contractual severance entitlement from 2 years to 30 weeks. The employer gave 2 years of notice, and Mr. Ronco objected to the change and refused to accept. The employer waited 2 years, and then at the end of the 2-year period, informed him that the change was effective. Mr. Ronco resigned and brought a claim for constructive dismissal. ultimately he was successful. The decision is a bit of a game changer for employers and employees. The decision was informative in terms of what the employees' options are in the event they're served with a change of a change of conditions of employment to their, a change to the terms and conditions of employment in a material or fundamental way. In short, the employee can accept, reject, or reject but work in protest. And it's the work in protest that we want to just make a quick point on because it kind of informs what you should and shouldn't be doing when you're making changes to terms and conditions of employment. If the employee rejects but continues to work, the employer should respond by terminating the employee with proper working notice and offer re-employment on new terms and conditions of employment. The offer of new employment on new terms is especially helpful because at law, an employee has a duty to mitigate his or her loss by finding new employment. So if we quickly revisit the Lancia decision, in that decision, if she had rejected the change initially, the employer would then say, okay, we're going to provide you with working notice of termination, we couple it with the offer of re-employment, and then in 18 months, if there's no job for you, you don't accept, then it mitigates your risk against constructive dismissal. So it's a bit of the machination is terminate and then couple it with an offer of employment on the new terms and conditions to protect yourself against the constructive dismissal damages. It is a bit of a mouthful, but again, if you have questions, by all means call us and we're happy to help. But this is kind of the machination that works in Ontario. In Quebec, it might be slightly different, Pat, am I right?
Well, in Quebec, it would be pretty much the same concepts.
Okay.
What we would see in Quebec that is different is we have statutory recourses that are available. So for example, any employee that has over 2 years of service can file a complaint for unjust termination with the labor board. And that would trigger a hearing, which can in itself trigger a reinstatement with full back pay. So for example, looking at scenario on slide 8, scenario 2, what we should note is that a recourse under 124 would not be open to a senior manager and would not be open to anyone whose position has been abolished. So that would not be covered. Looking at the concept of a poisoned work environment, in Quebec, we have also a provision that allows to file a complaint alleging psychological harassment, which is a very broad concept now. And in the past, the window to file a complaint of this nature was 90 days, and that has been increased to 2 years now, since June 2018. So it's a very broad window. And what happens there is, in the case of harassment allegations, it is not limited to senior managers or to someone that has 2 years. It is open to any employee. And the powers of the board are very, very broad. The board can order reinstatement, punitive or moral damages, back pay, termination pay in the event where reinstatement is not appropriate. So it is very, very broad. And what is interesting also to note is that about 4 years ago, there was an amalgamation of our Workers' Safety Insurance Board with our Workers' Labor Standards Board. And they created one organization which handles everything together. So what we are seeing now is that very often employees are going to file a complaint for psychological harassment along with a claim for workplace accident alleging a psychological illness. And they've now assigned one investigator to look at both, and one decision of the other is going to bind the other. So we now end up with an amalgamated case where you are handling not only a workplace accident, but also a claim alleging harassment at the workplace. So it's created an interesting dynamic, and because this is a new approach, our courts are still trying to see how they look at both, given that they both flow from different acts and different criteria. So that is really what is different from the Quebec point of view.